Appeal in the matter of McLeish and another, and Secretary of State for Environment, Food and Rural Affairs and another.
Thank you very much. Yes, Ms. Bird, can I just indicate that we've read the papers. We have, I think, a keen understanding of the issues. We may have some questions as we go along, but take your own course.
My Lord, yes. I appear on behalf of the appellants, as your lordships are aware. My learned friend, Mr. Westaway, appears for the first respondent. The second respondent, who is the Surveying and Order-making Authority under the Wildlife and Countryside Act 1981, Kent County Council, is not represented.
Yeah.
This is an appeal, my lords, against the judgment of Neil Cameron, King's Counsel, sitting as a Deputy High Court Judge. The learned judge dismissed the appellant's application, which was made under paragraph 12 of Schedule 15 to the Wildlife and Countryside Act 1981, to quash a definitive map modification order made by Kent County Council and confirmed by an inspector appointed by the first respondent. The effect of the order, my lords, is to move the legal alignment of the southern section of Footpath ZR281 in Doddington, Kent, so that it now runs, or part of it runs, through the appellant's courtyard at the rear of their home. The grounds of appeal contend, in essence, that the learned judge erred in law by finding that section 56 subsection 1 of the Wildlife and Countryside 1981, which provides that a definitive map and statement shall be conclusive evidence as to the particulars contained therein, applied to the current copy of the definitive map containing an apparent drafting error, and not to the original definitive map, which was made in 1952, following the full legal process under the National Parks and Access to the Countryside Act 1949. My Lord's, permission to appeal was granted by Lord Justice Lewison, and the reasons state that the question whether a mapping error is a modification of a DM, definitive map, is an important point. So, my Lords, in terms of timing, I propose to be no longer than 2 hours, and I will, of course, cut that short if appropriate. In terms of structure, I intend to divide my submissions into 5 main sections. Firstly, a very short overview of the case and the appellant's main contentions. Secondly, the legal framework and how I submit it applies in a case where the current copy of the definitive map contains an apparent error. Thirdly, the judgment and why I respectfully submit the learned judge erred in his construction of section 57(3) of the 1981 Act in particular, which contains the copying provision. Fourthly, given the importance of the point, my lords, my respective submissions on a correct construction. And finally, why I contend, my lords, that the inspector's decision would not necessarily have been the same had she treated the 1952 definitive map and statement correctly in law. And so, if your lordships are persuaded that the learned judge below did indeed err in law, then the court should exercise its discretion to grant the relief that we seek, which is the quashing of the order. So moving on to the first section, my lord, the overview of the case. This case arose because the owners of Victoria Bungalow, next door to the appellant's property at Yew Tree House, applied for planning permission to build on their land, and it transpired in the course of that process that the line of the footpath in question, as recorded on the current 2013 copy of the definitive map, runs through their cesspit and garage. As a consequence of that, the Surveying Authority for Public Rights of Way under the Wildlife and Countryside Act 1981, being Kent County Council, investigated and found that the current copy of the definitive map and statement of public rights of way in Kent did not apparently show the same alignment as the original definitive map and statement made in 1952 and published in 1967. The first result of that investigation, my lords, is a consultation order plan, which is at page 45 of the supplementary bundle. If I could invite your lordships, please, to turn to that.
Yep, page again.
Supplementary bundle 45, my lord. it can be seen that this plan is entitled Potential Mapping Anomaly and compares the current alignment, shown in purple, with the 1952 alignment showed by a dashed line.
Yeah.
The council then proceeded to make a definitive map modification order, which is to be found in the core bundle at page 136. And that order deletes what was thought to be the wrong route.
Sorry, can I have the page again, please?
Core bundle page 137, my lord.
Thank you.
And your lordships will see there that that is the schedule for the modification order, and it describes the path to be deleted and the path to be added. So the route that was thought to be wrong, the path to be deleted, is the route between point C and D on the order plan, which is over the page, page 138. And adds a path along what was thought to be the correct route, which is between points A, B, and C on the order plan.
Yeah.
Marked with a hatched line. So, my lords, the added route on the modification order, that is between A, B, and C, and the 1952 alignment on the consultation order plan are not the same. It is the first respondent's case that the inspector did not think that the 19...
if we look at the plan you showed us in the supplementary bundle,
Yes, my lord.
at page 45, that shows that the hatched alignment is the 1952.
It does, my lord, yes.
So the effect of the order is to go back to the 1952 route, isn't it?
No, my lord, in my respectful submission, it isn't. So the first plan at page 45 is merely, I must stress this, merely a consultation plan. This is the first plan that was produced by the officer in the course of the investigation.
Right, where do we find the 1952 plan?
So, my lord, that is in the appellant submissions in the court below. It's for the-
Can you show us the?
Yes, my lord, I can. If your lordship would bear with me.
There should be no mystery about this.
there should
I mean,
be no
I shouldn't have
mystery.
had to have asked for plans and photographs. These cases are all about presentation. This is a classic case where a picture is not only worth 1,000 words, but probably 10,000.
My
So
lord, yes.
let's see, you're showing us the 1952 map.
I am, my lord, going to do that. So if your lordships would please turn to page 102
Of the,
of the core bundle. And this is my skeleton argument from the court below, and it is extracts of the draft map, the provisional map, and the definitive map of 1952. There is unfortunately no convenient copy of the draft map of 1952.
Sorry,
But my
what
lord-
are the draft and provisional maps? It doesn't say.
I'm sorry, my lord.
What are the draft and provisional maps? It may mean an awful lot to the people who write them, but we need to understand it.
Yes, my lord. I propose to go on to that in a moment.
Now, what are the draft and provisional maps?
Yes, so the draft map, my lord, is the first map which resulted from the review under the under the National Parks and Access to the Countryside Act 1949.
So which year are we in?
We are in 1952.
Thank you.
My
So
lord.
I write against draft map. That's a draft map in 1952.
Yes.
And what is the provisional map?
The provisional map that is the map that was made following consultations on the draft map
Back in 1952.
back in 1952.
Okay.
Exactly so, my lord.
Thank you very much. And then the DM
And the DM
is the actual
is the result of that process
in
in 1952, and that is the map
1967.
published in 1967.
Thank you very much.
Thank you, my lord. So, my lord, the point of all of that background is to provide context for the Secretary of State submission that the inspector did not consider that any of the maps in that process, and did not consider that the 1952 definitive map correctly showed the legal alignment of the path. And that is set out in the first respondent skeleton at paragraph 4, subparagraph 3, which is at page 40 of the core bundle. And also in the same document, paragraph 56.
Sorry, you said, did I hear you paragraph 3?
Paragraph 4, subparagraph 3, my lord.
4.3, so it's as far as the review.
Yes. And that point is reiterated in the first respondent skeleton at paragraph 56, at page 54 of the core bundle. So, my lord, the appellants take the first respondent's position to be that the inspector made a finding that the 1952 definitive map alignment so the third one I took your lordships to a moment ago in the snips did not correctly show the legal alignment of the path.
So that's the 1952 DM.
1952 DM.
Well, where is that finding to be found, please, in the decision letter?
That, my lord, is the appellant's point. We argue that the inspector did not reach that explicit decision.
Oh, I see. I misunderstood you. Sorry. I thought you said she made a finding that the DM did not correctly show, but you're saying she didn't make that.
She didn't make any finding on it explicit. I beg your pardon, yes. So, going back, my lords, to the modification
But
order.
why, I'm sorry to be slow on the uptake. I'm sure everyone else understands this. Why are we looking at the 3 different, you say they're different, plans on whichever page was it? 102, I beg your pardon.
102.
Why are we looking at them?
Because the last map in that sequence, so the definitive map of 1952, my lord, is the map that we submit should be treated as conclusive pursuant to section 56(1) of the Wildlife Countryside Act 1981.
But were you making a point that there's some difference between these 3 different maps?
I was in the court below, my lord, but I don't need to make that point here,
Nor could you.
nor could I.
What do you say the 1952 definitive map shows?
As a matter of fact, my lord.
Yeah, I mean, where does it go? It's not.
Well,
It's not obvious to me that it's
no.
different from what the inspector said should be the position.
No, my lord, and I will go on to make more detailed submissions on this, but the basic point is we say that if the changes on the ground and the changes in base mapping between 1952 and 2013, when the copy of the map that the inspector was being asked to modify was published. So in that intervening period, if the evidence were to have been thoroughly examined, as the appellants invited the inspector to do, the conclusion would have been that there is no difference between the 1952 alignment and the 2013.
Sorry, the conclusion would have been?
There is no difference. There is no material difference between the 1952 and the 2013 alignment. Mr. and Mrs. McLeish, the appellants.
So in other words, there was no copying error.
There was a copying error, my lord, because it looks as if the 2013 map is different. But if it were to have been examined thoroughly, as Mr. and Mrs. McLeish contended it ought to have been, had, and this is the key point of the case, had the inspector treated the 1952 definitive map as conclusive, then we argue the outcome would have been, taking the change features and the change mapping into account, there is no material difference. But my lords, that's rather a tangential point, because it doesn't go to the essential question of whether the correct approach in law was taken to the 1952 definitive map and statement.
I thought you, I'm sorry if I'm not following, I do apologise, but I thought you started off by saying that the attempt in the most recent order to show where it was thought the 1952 definitive map line exists was wrong. They misdrew what the 1952 definitive map was trying to show, and that's why I thought you took us to the three plans. But are you saying that?
Well, my lord, that's what the council thought the position was when they investigated. So if I could take your lordship back to...
You said the order itself was wrong in purporting to reproduce the 1952 definitive map. Maybe I misheard.
No, my lord, I don't believe that was my submission. I'm sorry.
I do apologise.
No.
What this case needs is some overlays.
Well, my lord, it's
It's a very odd overview to start with, taking an opposition point to something in the respondent's skeleton. I'm quite keen to hear your case, building it up in blocks.
My lord, I propose to do that, and it may well be that I've overweighted the overview of the case, and as a result gone down tangents that don't assist the court at this point in time. But your lordship mentions overlays. The appellants did in fact present the inspector with overlays, trying to achieve precisely what your lordship says ought to be done. But unfortunately, the inspector didn't consider that those were produced in the correct way and didn't have regard to them. So I, of course, take...
He refers to them.
She does refer to them, but she didn't give them weight.
Yeah.
So, the order that the inspector confirmed adds a legal alignment between points A, B and C on the order plan, which is on page 138 of the court bundle. And part of that line runs roughly diagonally across the appellant's courtyard. That modification, as you're aware, my lord, was confirmed by the inspector following a hearing. And her decision, which I'll take you to in due course, is at page 126 of the court bundle. The appellants argued in the court below that the inspector was wrong in law because she failed to treat the 1952 definitive mapping statement as conclusive evidence of the position of the path. And the learned judge below rejected that argument for the reasons given at paragraphs excuse me, 31 and 39 of the judgment. And I'll go to those in detail in due course, if I may. Our basic point.
I mean, your main argument below was that the courtyard was a cul-de-sac, not the courtyard, the footpath was a cul-de-sac, wasn't it?
That, my lord, was ground C. We have resiled from that submission. We maintain, under grounds A and B, that it is the 1952 definitive mapping statement that falls to be treated as conclusive under the Wildlife and Countryside Act 1981 and section 57(3) and 3A, which I will go to, but just to lay the marker down now, those are copying provisions.
Can you just show us, please, where in your skeleton below you argued that the 1952 version was, you keep saying conclusive, I think you mean a rebuttable presumption, do you?
I don't.
What do you mean conclusive?
My lord, that goes into the question of two presumptions. So.
All right, well, let me ask one question at a time. First of all, can you show us where you argued for that?
Yes. So paragraph 70
Page.
on page 111 of the court bundle.
Thank you very much.
This is the end of ground A. So I say, in failing to start with the presumption that the 1952 definitive mapping statement is correct, and failing to address any reason why it might have been wrong, the inspector fell into fundamental legal error, which is fatal to the decision. And then the learned judge, at paragraph 31 of his judgment, which is on page 69 of the core bundle. Well, beginning with paragraph 30, the judge says it's necessary to consider the version of the definitive mapping statement to which the presumption applies. And then I'm recorded as submitting that the definitive mapping statement to be considered is the mapping statement prepared in 1952 under the provisions of section 33 of the National Parks and Access to the Countryside Act 1949. And then the judge gives his reasons why that is wrong in paragraph 31. And that conclusion is restated at paragraph 39 of the judgment at core bundle, page 71. The basic point we make, my lords, as to why that decision is wrong, and I need to make that good with detailed reference to the statutory provisions in due course, but the basic submission we make is that the copying provision in section 57.3 is a supplementary provision. It's explicitly entitled in that way.
Are you saying that when 57.3 is lawfully applied, it doesn't result in a new definitive map?
In essence, yes, I am, my lord, in essence. Purpose is expediency. I will, if I may put it like this. Section 57.3 does not speak to the question of whether a definitive map and statement is definitive with reference to section 53 subsection 1, which defines what a definitive map and statement is. That's the basic point we make. My learned friend and I have agreed as far as we can, a common ground and issues in dispute, or at least the issues we respectfully submit for to be determined by the court. That is at core bundle page 56.
Sorry, just before we go there, you've shown us, thank you, excuse me, the definitive map from 1952. Does the definitive statement shed any light, and have we got it?
Not on the considerations for this court, my lord. It doesn't.
Have we actually got it anyway?
Yes. So you certainly have a summary of it. At page 42 of my skeleton argument below, and that's on core bundle page 103.
My lord, the actual statement, if only for reference, is at page 35 of the supplementary bundle. That's the definitive version of the statement. Then there's, as with the map, there's draft versions of the statement that precede it. They're in the pages prior to that.
So it's supplemental bundle page
35.
Thank you.
Is that it? I hesitate to ask. Is that in 1952?
Published in 1967.
But yes, it's the same.
Well, I can come back to it, but the process started in 1952. Exactly where the events fell between 52 and 67, I'm not sure I know.
Thank you.
Sorry, you were going to the.
I was going to the statement, my lord. Yes. So. It simply reads Doddington, and then from Downcourt Road, and leads S and SE via Downcourt to Doddington. And it makes no material difference to this decision, my lord, because the question here is simply whether the inspector treated the definitive map correctly in law.
Yes, I was hoping that the definitive statement might say either through Yew Tree Cottages Courtyard or through Victoria Bungalow.
My lord, if only it had.
I was hoping.
If only it had, my lord, we obviously wouldn't be here. So we are And my learned friend and I have agreed, as I say, common ground as far as we can. On core bundle page 56, the point of common ground we've agreed is point 6, which is over the page on page 57. We say is of particular importance to the appellant's case. And that is, we agree that an error on the copy of the modified definitive map made under section 57.3 of the 1981 Act is not a modification within the meaning of section 53. So what I submit we have agreed is that if indeed the right-of-way was copied in error onto the 2013 current copy of the definitive map that the inspector was being asked to consider and to modify, that is not a legal modification within the meaning of section 53.
You agree also that paragraph 4, DMS can only be modified by way of an order.
Yes.
The inspector referred to a number of versions post 1952 as being the revised definitive map. Were there at any stage after 1952 any orders made?
There were not, my lord, no.
Are you, when you answer that question, are you talking about the specific footpath or the definitive map as a whole?
I'm talking about the specific footpath, my lord, and
So
that
there were orders modifying other parts of the definitive map.
there must have been, my lord, yes, because if there were not, then
You
no
couldn't
copy.
exercise the power under section 57.3.
That's precisely our
So you do
submission.
accept that the power under section 57.3 was lawfully exercised when the council purported to do so.
When they purported to make copies in 1987 and 1923, absolutely, yes, my lord, that was lawful.
So what were the orders? They simply covered a larger area, did they? The whole of Kent or
No. No, my lord, that would in one way have been easier. The way it works is this: if there is a definitive map, it's probably better if I take you, my lord, to paragraph to section 53 of the Wildlife and Countryside Act straight away, and then the context will be.
Is it done on a parish by parish basis?
No, my lord, it's done on a right of way by right of way basis.
You take the whole length of the path, is that right, or the right of way, like we saw in the definitive statement a moment ago, and then the map shows different sections of it.
Not quite. If let me put it like this. Well, let's suppose for a moment that I'm a keen walker, and I walk a path across the field that I think is a public right of way. I look on the definitive map in Kent, sake of argument, and I don't see it shown there. Now that says nothing as to whether or not I do actually have a right, but I might wish to make an application for a modification order to add a public right of way on foot across that field. So it's done on a path by path basis. But it is probably better to answer your lordship's, my Lord Justice Holgate's question, if I turn to the relevant provision in the Act straight away, because that will give you the necessary context.
So this is your second heading.
So I've gone into my second heading, my lord, and I've rather skipped over the National Parks and Access to the Countryside Act 1949, under which the 1952 map was made and published. So I think I can summarise the point I want to make about that very quickly before I take you to section 53. And the point simply is this, there was an extensive process of investigation, publication of a draft provisional and a definitive map, public consultation at every stage, and my lord, the references I was going to take you to, and I will just give them to you if I may.
Please do.
So
My heading is legal framework, so
Legal
whatever
framework.
submissions you want to make.
Legal Framework, National Parks and Access to the Countryside Act 1949. Important plainly because the 1952 map we say should be conclusive comes out of that process. The process itself summarised by Lord Justice Purchasing Crown and Secretary of State for Environment ex parte Sims, which is Volume 2 of the Queen's Bench Reports 1991, page 354. The relevant passage is at page 364. Authorities bundle, page 72. Heading, the Act of 1949. The relevant paragraph begins, notwithstanding the reference in the preamble to creation of public paths, relevant parts of Part 4 of the Act appear under the subheading ascertainment of footpaths, bridleways and certain other highways, and then the judgment summarises the sequence of the sections under the 1949 Act. The purpose of all of that, so the purpose of that process is helpfully described, my lords, by Mr. Justice Evans Lom in Todd and the Secretary of State for the Environment, Food and Rural Affairs. Relevant passage is at page 2483, which is at Authorities Bundle, page 128. Again, heading the 1949 Act. And explains before the enactment of the 1949 Act, there were no official records of public rights of way. If dispute arose, and then that was determined by litigation in the ordinary courts, usually between the landowner and the personal persons asserting the right of way, I beg your pardon. And then reference is made to the judgment of Lord Denning, Master Rolls in Ex parte Hood. Over the page, the object of the statute is this: to have all our ancient highways mapped out, put on record and made conclusive so that people can know what their rights are. That's the point, the purpose, my lords, of the 1949 Act. And that carries over to the 1981 Act in terms of statutory purpose. The result of the process, so what is the status of the definitive map that is made under the 1949 Act? That's also set out in the judgment in Todd, and this is at paragraph 38. Which is on page 133. So halfway through that paragraph,
This is paragraph.
38, my lord,
Thank you.
CB 133, halfway through, after the reference to page 710b is it said what would result, i.e. from the 1949 Act process, would be a temporarily unchallengeable right of passage by the public over the land in question, which would not be capable of challenge pending review by the authority or the exercise of the powers of deletion from the map conferred by the 1968 and 1981 Acts.
That's dealing with where there was never a right of way and one was mistakenly shown.
Exactly so. That was the question. That was another question in Todd, but this part of the judgment is relevant because it encapsulates what the legal status of a right of way on a definitive map made under the 1949 Act is, and that is a temporarily unchallengeable right of passage which is not capable of challenge pending review by the authority or the exercise of the authority's powers of deletion. So applying that to the fact of this,
Are we going to look at the statutory framework at some stage?
my lord, yes, so to summarise, the statutory framework is the 1949 Act, which I will deal with first. Then the Wildlife and Countryside Act 1981, and your lordship did ask about something relating to section 53, but I will move on to that in due course. So it's those two acts, plus section 32 of the Highways Act 1980, but I will make clear, I hope, where that becomes relevant. So, my lords, we're at the point where the legal effect of the 1949 Act has been established. So, a temporarily unchallengeable right of way.
Sorry, I'm not understanding this. In what sense is it temporarily unchallengeable? Which statutory provision is that relating to?
So that, my lord, is in the 1949 Act. And it's the same conclusive evidence provision that translates over to section 53.
Thank you. So where is it in the 49 Act?
So that's
Is it around section 32?
yes.
32 for page 11 of the authority?
That's where the relevant provisions begin, my lord, and on page 11,
Yes, 32.4.
32 a definitive mapping statement shall be conclusive evidence.
Then the second bit of my question is, in what sense was the judge saying temporarily?
Well, because, my
Because
lord,
that section's not saying that.
no, because, my lord, the 1949 Act contained a requirement for a periodical review of the map. So
we don't need to know about this.
you don't really need to know about it, but
What do we need to know about the passage referring to the straightforward point is 32.4.
well, that is the straightforward point,
Yeah,
my lord.
okay.
Yeah.
Thank you. I'm trying to keep up.
My apologies.
It's not really Todd that decides that, is it? It's Sims and Trevelyan, which say that the conclusive evidence provision in the statute, 1949 or 1981, doesn't apply to a review process. For a while, people seem to have thought that it did, but
Yes.
those cases authoritatively hold that it doesn't.
Yes, my lord, that is so, but the reason that I point to the reason that I pointed to that paragraph in Todd is because it relates specifically to a map prepared under the 1949 Act, and I will go on to submit that is important. So moving on to the 1981 Act, my lords, and
I'm sorry, can we look at the 1949?
Maybe 52.
Well, with the 1949 Act, just to see where we start off. Would it not be helpful?
my lord, yes.
I mean, just very shortly, I was just looking at section 27, page 3. Section 27 says that each county council has to prepare for its area, just to do a survey, and then at the top of the page, page 4, a draft map of their area.
Yes.
So it starts off as being a map on a county basis.
The very
But
first.
as you move down to subsection 5, the duty to prepare a map relating to it may be discharged by preparing more than one map.
Yes.
But then together they comprise the definitive map for the county. Have I understood in a nutshell?
In a nutshell, my lord, yes. But the very first stage is the survey.
Yes,
We're
but
carrying out-
it's a survey for the whole county, which translates into a map for the whole county, unless they decide to have more detailed maps comprising the whole definitive map.
In essence, my lord, yes. In
The
essence.
reason why I asked this, I was going back to the order made in this case to pick up the question my lord, Justice Mayles was asking. It's at the back of the core bundle to see what in this instance they were modifying. And
Sorry, which page?
it was core bundle, I think, 135.
Yeah.
And then look at the title. Definitive map and statement for the County of Kent. Kent County Council Public Footpath ZR281 Doddington. So, when my lord asks the question, has there been a previous order modifying the map, we need to understand what that applies to. So we can apply the statutory provision in section 57.3.
Yes, my lord.
I think you did say that it had been applied lawfully.
It had, and this is the problem that arises in this case. So it's best, my lord, if I
In fact,
turn
if
you.
I go to page 136, hereby orders that halfway down the page, sheet 107 of the definitive map shall be modified, etc., etc.
Yes.
So there's something called sheet 107 within the overall definitive map.
Yes.
And when they did the copying out, what did they do? Did they just copy out sheet 107, whatever that is, or did they copy out the whole map? So they had a nice new shiny map without lots of creases in it.
The latter, my lord, because they found it
So
expedient.
across the whole county of Kent, when the section 57.3 power was exercised, lawfully as you accept, there would have been some modifications pursuant to orders somewhere in Kent.
Yes,
Okay.
but not every.
Not this section.
Not
of
this
it.
section,
Yes.
and not every section.
No, of course. No, thank you. Sorry, I beg your pardon. But that's all I wanted to ask from the 49 Act. Thank you. You were about to move to the 81 Act, I think, when I interrupted.
My lord, I was not at all. So. Before I go on to the detail of the Act, the overarching submission on it that I intend to make is that the current definitive map, i.e. the 2013 map in this case, is conclusive evidence of a right-of-way under section 56, unless and until reviewed under section 53. That's common ground, not contentious. at that point,
Just stop you there. You say the current definitive map of 2013.
yes. Current copy.
Is it the current definitive map because there is an order saying this 2013 map is the current definitive map?
No, my lord,
Well, why is it a definitive map if there's no order saying so?
because it has been copied in accordance with the provisions in section 57.3, or parts of it, sheets of it, have been copied. Oh, sorry, I beg your pardon, no. Parts of it have been modified, a copy has been made of the whole.
Yeah, sorry, picking up my lord's question, when you say parts have been modified, do you mean modified in the past pursuant to an order?
Precisely.
So as to attract, so as to engage, section 57.3.
Exactly, exactly, my lord.
When section 57.3 was relied upon by the county council, was the new copy a complete copy of the whole definitive map for the county of Kent, or was it for some lesser part which included this footpath? It may not matter, but just for clarity.
I'm afraid I don't know the answer to that, my
It may
lord.
not matter.
Have I written down your submission accurately? 2013 is definitive because it has been copied, even though there is no order saying that it is definitive.
Yes, and that is by virtue of section 57, subsection 3.
So it becomes definitive even though it has been copied inaccurately. So it is not a true copy, it is
Well,
a
look,
false copy.
This is the
I mean,
problem.
Well,
This
it is
is,
the problem, but we need to know your answer to that.
my lord, I will give an answer, but I'm afraid I have to do it in stages. What I'm trying to do at the moment is set out my overarching submission, so the context for the detail I will go into, I hope.
All right,
makes
well, so
sense.
long as you promise to come back to that question.
I
I'm quite happy.
absolutely will. So, at the point of review, and that means review under section 53, subsection 2. So, for example, somebody thinks there's an error on the map, or somebody thinks they want to divert a right of way, or whatever the reason is. There is only an initial presumption in favour of the definitive map and statement under review. As my Lord Justice Males observed a moment ago, that's the presumption that comes from the judgment in Trevelyan. So in ordinary circumstances, if there is no apparent conflict between the original definitive map and statement and the current copy, so there's no apparent error, the position is uncomplicated. On review, the decision maker is to treat the definitive map and statement not as conclusive under section 56(1), because otherwise they wouldn't be able to make any changes to it by law.
So just so I follow, you're talking about a situation where there's no error in copying.
Yes,
In other words, it's reproduced what was on an earlier definitive map.
yes,
So we're talking about a case where someone, member of the public, is saying, well, actually, there's evidence to show the right of way is somewhere else.
for example.
But in that simple situation, you start off with the working presumption, the Trevelyan presumption, that it is where the definitive map shows.
Yes,
I'm following.
I'm grateful. However, we submit that initial presumption in Trevelyan does not apply if there is evidence that the proper procedures were not followed in preparing the map.
sorry, which map? The copy map.
the copy map. And I take that from the judgment of Lord Phillips in Trevelyan. The relevant passage is paragraph 38. At page 104 of the authorities bundle. So where the Secretary of State or an inspector appointed by him has to consider whether a right-of-way that is marked on a definitive map in fact exists, you must start with an initial presumption that it does, and if there were no evidence which made it reasonably arguable that such a right-of-way existed, it should not have been marked on the map. Then, in the absence of evidence to the contrary, it should be assumed that the proper procedures were followed and thus such evidence existed. So my submission, if there is evidence that the proper procedures were not followed, then the initial presumption should not apply.
Your submission was that the proper procedures were not followed in preparing the copy map.
Yes,
He's
because
not talking about a copy map here, is he? He's talking about preparation of the definitive map.
and that, my lord, is exactly the point. So all modifications are made to the current copy of the definitive map. By virtue.
Well, they're made to the definitive map.
Well, my
Can
lord-
you use the year so we can follow which map you're referring to?
2013. So the copy that the inspector modified, copy to which the order related, was the 2013 current copy. And it was regarded as, to use the statutory language, the definitive map and statement for the purposes of modification by virtue of 57.3. So the most important part of Trevelyan for the purposes of this case is paragraph 38. And it explicitly says, in the absence of evidence to the contrary, it should be assumed that the proper procedures were followed and that such evidence existed, and thus an initial presumption should be made that the right-of-way was correctly recorded. Now, in my submission, if there is an apparent difference between the original definitive map, which was definitive by virtue of section 32, subsection 4 of the 1949 Act, and remained definitive until the point of review by virtue of section 56(1)
Of the 1981.
of the 1981 Act, my lord, yes. So if there is a difference, at least on the face of it, between the original definitive map and the current
Current copy under section 57.3.
under section 57(3), which was the 2013 map in this case, that in my submission is evidence that the proper procedures were not followed, because it should be the same.
Proper procedures were not followed when?
In the preparation of the map, my lord,
In the preparation of the copy.
in the preparation of the copy.
Well, that's, which is it? Preparation of the map in 1952 or the preparation of the copy in
Preparation of
2013?
the preparation of the copy, my lord, because the 1952 map was made following a full consultation, modification and review process under the 1949 Act. That was definitive. Nothing.
Subject to the provisions
Yes,
that it could be reviewed, changed, whatever.
exactly, my lord. But the fact is that it wasn't.
Right, so this is the proper procedures were not followed when making the copy.
When making the copy.
And you discern that because there's a difference.
I do, and I draw support for that submission from the judgment of Mr. Justice Pitchford in Norfolk County Council and the Environment Secretary. The relevant passage being paragraph 63B, which is page 161. Of the authorities bundle. Now, well, was that in that case the court was being asked to decide whether, if there's a conflict between the map and the statement, which one prevails. So it's not precisely the same question as here, but we take an important point from this passage. So your lordships will see that paragraph A at the top of page 161 of the bundle is a quote from Trevelyan: "In the absence of evidence to the contrary, it should be assumed that the proper procedures were followed and thus such evidence existed." And then the learned judge goes on to say, "The very fact that the map and statement are in conflict tends to demonstrate that an error occurred in the preparation either of the map or the statement, or possibly both. It does not seem to me that in circumstances such as these, the factual assumption of regularity in the preparation of the map, but irregularity in the preparation of the statement, can be justified." So, my lord, in my submission, that ought to apply as a matter of good administration and common sense.
This is really dealing with a different topic, isn't it? It's where the definitive, or in any given year, the map and statements are in conflict with each other, and therefore one of them must be wrong, and you've got to reconcile it in some way. Here, we don't need to worry about that, do we? Because we've got findings by the inspector about an eastward drifting of the line.
No, my lord, quite. But the immediate problem is that there is no direct authority as to what should happen if there is a difference between the original definitive map and statement and the current copy, which would be expected to be the same.
Can I try and see if I've understood the argument? In the simple situation we touched on a moment ago, you have a copy map, which is now, by virtue of section 57.3, the definitive map in the situation we imagine. And it cartographically shows the right-of-way on the same alignment as the earlier original definitive map. but someone wants to come along and say, actual fact, as a matter of fact, the right of way is somewhere else. And in that situation, the Trevelyan presumption applies when you look at the evidence in the case. There is a presumption in favour of the copy map alignment. But you say it's different, as I understand it, if you're dealing with a situation where you're only in front of an inspector because the county council are saying, when we copied this part of the original definitive map, we got the alignment wrong, we made a mistake. You say, in terms of paragraph 38 of Trevelyan, that is an error in the procedure which was followed, the procedure of copying, and where that applies, as a matter of law, there's no scope for applying the Trevelyan presumption in favour of the alignment shown on the copy map. Is that it in a sort of nutshell?
That's it precisely, my lord.
I mean, where you have a copy which is not a true copy, and therefore you have the conflict between the current definitive map, whatever version that may be going right back to 1952, and the copy, there are two possibilities, aren't there? The first is to say that the current copy, even though it has been inaccurately copied, is temporarily conclusive under section 56, and on review is treated as subject to the presumption against change, the Trevelyan presumption. That's the first possibility, and it has the advantage that if ramblers or whoever want to find out where they can go, then they're looking at a map which is what the county council will refer them to. Or the alternative is to say, well, it's not a true copy, so it is the current definitive map and not the copy which has the status under section 56 and the presumption against change, because the copy has to be a true copy if it's going to have status under section 57. I mean, those are the alternatives as I see it, and you go for the second.
Well, essentially yes. But my lord, if just bringing it back to the number of this case, which is how the original definitive map and statement of 1952 ought to be treated, and what the options were for the decision maker in respect of how they treated that, and if there is an apparent error on the current copy. In my submission, there are actually three options for the decision maker in that event. So the first option is that the decision maker can treat the original map, the 1952 map, as simply another map to which they are required to have regard as evidence of dedication of the right of way, pursuant to section 32 of the Highways Act 1980, and this is where that provision comes in. If I could ask your lordships please to turn to that.
Well, before you do that, do you want to give us the other two options that you
Yes.
say? My lord gave you two. You didn't seem that you accepted either of them, any of them. What are your other two then, if they're not his two?
So, my lord, first one, section 32.
Well, the first one is the one that they can treat it simply as another map to which they must have regard,
Yes.
and that's the Highways Act, to which you'll come back. What are the other two?
Which map is that? You're talking about the copy or the original one? The copy, presumably.
No, the original.
Oh, I see. Sorry, big pardon.
My lord, I beg your pardon.
Yeah.
Secondly,
It's just simply a material consideration.
just it precisely so, and it's up to the decision maker what weight they
What
give
weight?
it in accordance with the list.
Number one.
Yes. Number two, they could treat the original definitive map and statement as conclusive pursuant to section 56(1).
for review.
Yes, that's my argument is that they could do that, and if I could just lay that marker down now, and when I
Yeah,
go on to look
yeah.
at section 56(1), I'll endeavour to make that good. But they could do that, and they could do it arguably. I don't say this is the right approach, but arguably they could do it without considering whether the proper procedures were not followed, I beg your pardon, in compiling that original map. So option 2, in a nutshell, is the decision maker applies a once and for all approach to the original map and says, well, that's it. I don't say that that's right, because it doesn't allow for the possibility of error in compiling the original definitive map and statement. So that, in my submission, is too restrictive approach.
Yeah, but that's a different factual situation. We're just dealing with a case where it's said you're assuming there's an error in copying. That's got nothing to do with whether the original map was wrong.
Well, my lord, in my respectful submission, it absolutely does.
It's a separate point. If the county council got the original map wrong, that's a freestanding argument as to whether or not they got it right, but they copied it incorrectly.
My lord, in my submission, it's not, because section 53(2) makes it clear that the map which is under review is the current copy of the map. It is not the original map and statement. The original map and statement is quite apart from the section 52(3) review procedure. And that is made clear in the inspector's decision letter. And this may assist on the point, my lord. So she says...
Well, do you want to give us the third one before we
Yes.
go elsewhere?
So number 2 was
All I'm trying to get. I have a very simple brain. When you say there are 3 options, I like to write down what they are. I'm
Third
very
one.
conscious of the time. We'll try not to ask you too many more questions. Third option.
Third option, and this is, in my submission, the right one. The decision maker treats the original map and statement as conclusive, pursuant to section 56(1), but with consideration of whether there is evidence that the proper procedures were not followed in compiling the original map. And that is what the county council did in this case. And we know that because the officer says so. At paragraph 110 of their report, which is at supplementary bundle page 19. I'm going to read it out because in my submission it's important and this is the right way of doing it.
So did you say page
Supplementary bundle 19 and it's paragraph
19?
100
Sorry.
paragraph 110. reads the case officer is not aware of any evidence that the draft map, provisional map and 1952 definitive map did not follow due procedure. Therefore, it should be assumed that proper procedures were followed and that evidence existed and it was considered appropriately when recording the public footpath on the 1952 definitive statement. It goes on to say this document can therefore be considered conclusive evidence in law of the particulars they contain. In my submission, that's exactly the right approach.
But if it's right, it's right because it comes from the statute,
Yes.
not because it's in an officer's report.
Well, quite, my lord, but I point to it simply to illustrate. So one short point on that before I move on. I'm mindful of the time, my lords. If there is evidence that the proper procedures were not followed in taking into account the original definitive map and statement, if there was no such evidence in this case, but if, then in my submission what follows is that the map and statement is taken into consideration as evidence pursuant to section 32 of the Highways Act 1980 and given whatever weight the decision maker thinks fit. But if there's no evidence, as here, of a flaw in that procedure, then the original definitive map and statement should be treated as conclusive.
In the review.
Yes. Bearing in mind, my lord, that the review is happening to the current copy. It's not happening to the original definitive map and statement.
The officer's understanding of what the definitive map of 1952 shows is at paragraph 42,
Yes.
which is that it goes along the eastern edge of yew tree cottages. So, in other words, it passes through the same land as the inspector said that it should.
Yes, my lord.
But you say that's wrong?
Well, my lord, it's evidently it's a matter of fact. What we say is that the inspector didn't treat that definitive line as conclusive in her decision letter. That's not the premise she started from, so her factual conclusions are an error.
Your complaint is she didn't apply section 56 to the 52 map, is that right?
Yes.
If she had done so, what would have been the legal effect? If it's
Well,
conclusive.
I'm sorry, my lord.
If it's conclusive, pursuant to section 56, albeit this is a review, but if it is, what's the legal effect then of applying section 56 to that map?
Well, the legal effect is that the inspector then has to consider whether the alignment on the modification order in front of her reflects the correct legal alignment in the definitive map of 1952 or not.
If she had treated it as conclusive pursuant to section 56, that would have been a clear error of law. She would have been flying in the face of at least 2 Court of Appeal authorities that you've shown us.
Well, my lord, in my submission, she wouldn't. She wouldn't have been, because the initial presumption, the initial Trevelyan presumption, should not apply when there is
They're
evidence.
two completely different things. One is a conclusive evidence provision which applies between reviews. The other is a rebuttable presumption which applies in the course of a review, which has nothing to do with section 56 It's derived from the fact that it is assumed that unless the contrary is shown, that the proper and careful procedures set out in the 1949 Act were followed, and at each subsequent modification stage.
In my submission, my lord, that's not the position, because the review taking place under section 53(2), which is the point at which conclusive evidence becomes an initial presumption, is not a process being applied to the original definitive map and statement. It is not the 1952 map that was under review.
This argument assumes that the 2013 map, which was the subject of review, was not a definitive map under the 1981 Act by virtue of section 57(3).
Yes.
Whereas previously you accepted it was the definitive map by virtue.
I'm sorry, my lord, I don't quite follow.
Previously, in answer to a question, you had said section 57(3) had been applied lawfully by the council, and it applied to the 2013 map.
To the map as a whole, yes. And that's not in any way problematic, my lord, in normal circumstances. But it is problematic when the right-of-way appears in a different position on the current map as compared to the 1952 map, and there is no legal order to explain that apparent change. It is simply a sequence of copies.
A copying error.
A copying error, exactly. So, my lord, I'd better move quickly to section 53(1) of the Wildlife and Countryside Act. And it may be that I don't need to spend too long on this because much of the ground has been covered. But it's at page 17 of the authorities bundle. And it defines definitive map and statement. And there are three options in subparagraphs 1A, B, and C, all of which are subject to section 57(3), which is plainly the critical copying provision. So the definitive map and statement, for the purposes of modification, it's either going to be the latest revised map and statement prepared for the area under section 33 of the 1949 Act, or if there hasn't been such a statement prepared under the 1949 Act, then it's the original definitive map and statement prepared for that area under section 32. C isn't relevant because there was both an original map in 1952 and a revised map and statement in 1970. So if the map had not been copied in 1987 and 2013, then definitive map and statement the definitive map and statement would be the latest revised map and statement because one had been prepared in 1970.
You accept that the latest revised map and statement for these purposes is the 2013?
No, my lord, I do not. I do not, because because of the way I say section 57 subsection 3 should be
Right, then
construed.
just tell me, which do you say is the latest revised map and statement?
The latest revised map and statement prepared in definitive form under section 33 of the 1949 Act is the 1970 map.
Right.
Now,
So,
for the purposes...
so therefore the second option doesn't apply.
Well, my lord, in my submit, this is a difficult point for the appellants because we have argued all the way through that it should be the original definitive map and statement, the 1952 map.
But it can't be just on the words of 53(1), because you only get to B if there isn't a revised map and statement.
That's correct, my lord, but it doesn't affect the principle in my submission, which is that section 57(3) should not operate to remove, disapply the conclusive evidence provision from any of the maps.
From
Which may
any
otherwise,
of the maps.
I beg your pardon, my lord, any of the maps which would otherwise fall within the meaning of definitive map and statement in subsection 1. So it's a point of principle that we argue.
Well, you'll have to show us an authority that could possibly support that. But in the meantime, can I ask you, the 1970 map, you've shown us the bit of the definitive map that you rely on by reference to your submissions. What's the best place to see the 1970 map?
Well, my lord, in my submission, well, that's also in my skeleton argument, but it may be that the more helpful point is the way the inspector deals with it.
No,
You've
very
got
sorry.
it, my lord, on supplementary bundle page 37. That's the extract of the 1970 version.
Supplementary bundle 37.
Was it basically the same alignment as the 1952 map?
That's the point we make, my lord,
So
yes.
the error hadn't occurred by then. That's a short point.
That's the short point.
Yeah.
Now the important point is this in my submission. The definitive maps and statements prepared in 1987 and in 2013 were not prepared under subsection 1A, B or C. They weren't prepared under the 1949 Act. So the only way they become definitive and benefit from the conclusiveness provision in section 56(1) is if they are copied in accordance with section 53, subsection 7. Thank you. Subsection 3. Before I go on to that subsection, I need to very briefly mention section 53.
Sorry, what was your last reference? The only way they become definitive is if they are copied in accordance with
Section 57(3).
57.3. Thank you.
And it's only if that happens that section 56 applies to the 2013 map.
Yes.
And you're saying it shouldn't have been, section 56 shouldn't have been applied in the review process before the inspector to the 2013 map.
Exactly so, my lord.
Did she actually do that?
I'm sorry.
Did she actually do that? Did she apply section 56 to the 2013 map?
No, my lord.
I didn't
No,
think she did either.
didn't.
So what's the problem?
Well, my lord, the problem in my submission is that section 56,
Should have been
Well,
applied to the 52 Act.
it should have been applied,
52 order, I beg your pardon.
it should have been
52 Act.
applied to a definitive map and statement. That's the
Because
bit.
your basic submission is section 56 conclusive effect is to be applied in the review process.
Yes, and I don't understand that to be disputed, my lord.
As my Lord Justice Males observed a moment ago, it seems to be contrary to the Court of Appeal authority. I mean, we all understand that section 56 applies to the world at large once you've got a definitive map, so that everyone can regulate their affairs and walkers can know where the footpath is. But what's the authority which says that section 56 is a relevant statutory provision when you come to operate the review process, when you're considering a modification?
Section 57.3 itself, my lord. Perhaps I can turn to that.
Thank you. And you say 57.3 applies. Section 56.
Yes, and
Okay.
yes, I say it does.
Thank you.
It's at page 25 of the authorities bundle. And it says, where in the case of a definitive map and statement for any area which have been modified in accordance with the foregoing provisions of this part. It appears to the surveying authority expedient to do so, they may prepare a copy of that map and statement as so modified. So the first point to make is that the discretion to prepare a copy arises only in the case of a definitive map and statement which has been modified in accordance with the foregoing provisions of Part 3 of the Act. That's the threshold criterion, and expediency is obviously a matter for the authority. And it's crucial in my submission that that subsection is read with subsection 3A, because 3A explains the criteria for regarding the map and statement as having been modified in accordance with the foregoing provisions of Part 3. And it says, whereas respects any definitive map and statement, the requirements of section 53.2, that's the relevant provision, section 55 doesn't matter for these purposes. Where the requirements of section 53.2 has been complied with, the map and statement are to be regarded for the purposes of subsection 3 as having been modified in accordance with the foregoing provisions. So what that means,
Without having to comply with section 54.
section 54, my lord, is not,
Yes.
is not, yeah, well, yes,
Yes.
exactly, my lord, but it's not relevant, it's been repealed. So it's only if any definitive map and statement, the wording of the statute in 3A, if any definitive map and statement has complied with the requirements of section 53.2, and those are the requirement on the surveying authority in a nutshell to keep the map and statement under review and make such modifications to it as they consider necessary. So the review process. it's only then that the map and statement in question is to be regarded for the purposes of subsection 3 as having been modified in accordance with the foregoing provisions of this part. And it's only then that the surveying authority may prepare a copy of the map and statement as so modified, i.e. modified in accordance with section 53, sub 2, that they may prepare a copy of that map and statement as so modified if they think it's expedient to do so. So
are you saying it's only if you've got a situation which falls in subsection 3 capital A that subsection 3 applies?
that's how I would read the
But
provision.
subsection
Yes.
3A was inserted in 2000. When the Act was originally enacted, that wasn't there. So subsection 3 must have had a meaning which didn't depend on subsection 3.
That must be the case, but it was in.
Forgive me, all subsection 3A is doing is to extend the meaning of subsection 3. It's trying, I hesitate to use the word clarify, the situation by dealing with the circumstances which it covers. And it seems to be saying, although you say section 54 has been repealed since, it's saying certain matters are treated as falling within 57.3, despite whether or not section 54 has been complied with, perhaps at some point in the past. But it's footnote 3 which says this comes about through the 2000 Act. Anyway.
Well, my lord, yes. So so 3A was in force at the time the modification order was made. It was in force at the time the inspector made her decision, and plainly it was in force when the learned judge reached his decision. And so any decision that your lordships reach on how the original map and statement falls to be treated in the event of an error on the face of the current copy must, in my respectful submission, take 3A into account.
Do you need 3A? I mean, in 3 it says, which have been modified in accordance with the foregoing provisions. Well, if section 53 hasn't been complied with, it won't have been modified in accordance with the foregoing provisions. It will have been modified in some other way. Isn't that a route to what you're saying?
It is, my lord, and that certainly helps the argument that I'm making.
Okay.
But section 3A is very specific in pointing to the review procedure under section 53 too. So yes, as my lord, Lord Justice Mell says, there is an equivalence there.
Yes, but I thought we'd been through this before. I understand you to be saying that in terms of the foregoing provisions, in particular section 53, this particular section of Footpath has not previously been modified. On the other hand, the definitive map elsewhere, but the same definitive map has been.
Yes.
You said that earlier on, and therefore I think you accepted it followed that section 57.3 was engaged.
Yes. But, my lord, this is the nub of the case. We say it should not be construed as, so section 57.3 should not be construed as depriving the original definitive map and statement
Section 56.
of section 56.1.
That's a separate point. Yeah.
Yes, I mean we have to make the first concession plainly, but our main argument is it should not be construed in that way.
Well, I think I'm sure it's my fault, but I think I was asking you, could you show us where in subsection 3, where it does properly apply, it prevents, oh sorry, no, I'm not going to ask the question, sorry. You've been there. I beg your pardon.
Not at all. So, my lord, just to summarise this in entirely practical terms, as my lord Holgate said earlier this morning, what happens in practice is that the authority makes modification orders to rights of way, perhaps in any place on the map. Only parts of it may be modified and others may not be. As long as parts of it have been modified in accordance with section 53.2, section 57.3 allows the authority, if they think it's expedient, to prepare a copy.
And that then becomes the definitive map.
No, it doesn't, my lord, and this
That's
is
what it says
in my
the
submission, lord.
subsection.
It doesn't.
Okay.
It says, and this is an important distinction in my submission, it says the map and statement so prepared, and not the map and statement so modified, shall be regarded for the purposes of the foregoing provisions of this part, being modification and conclusivity under section 56, as the definitive map and statement for that area. Shall be regarded as, in my submission, is deliberately different from section 53.1, which says the definitive map and statement means.
It's a deeming provision, isn't it?
In essence, it is, yes, my lord. But it would be very unusual.
And forgive me, if you go back to section 53, what was the point of Parliament saying subject to section 57.3?
Administrative convenience, my lord, because it's 57.3 that allows the county council to have one map and statement, a single point of truth, as it were, to which they make modifications.
Give me, your submission is that section 53.1 is telling us what the definitive map is and state.
It is.
But then my question is, why in those circumstances does it say subject to section 57.3 or indeed 57A1?
Because
Then the implication is what they contain is something else which tells you in those circumstances what the definitive map is.
I follow that, my lord. Yes, but in answer to your lordship's question, what's the point of putting section 57.3 in if it's only the original maps to which section 56.1 should.
Can I ask an idiot question? Why do county councils make copies of these maps? Is that because there must be an original document which is sealed somewhere? Is that right? County Hall. Does it sometimes get into very poor condition?
Yes.
And that's why you make a copy.
That's why you make.
So if you're going to make a copy, it's not just administrative convenience, is it? You're actually producing something which you want physically to be the new definitive map.
Well, yes, my lord. I mean, I would.
Rather than going back to the tatty copy, which was falling to pieces.
Exactly so. I would submit that is administrative convenience and the same thing as expediency, but I don't think it gets me any further.
No, thank you.
So.
And they have to have copies available in different parishes so that people can come and look at them.
They do.
And this is all in the world when everything was in paper.
Yes.
Yeah.
Now things are digital. Perhaps the need for copies is less obvious.
That's exactly right, my lord. And the authority is under a duty to keep all copies of preceding definitive maps and preceding modification orders.
There is a duty
There is a
somewhere in the
duty to do
statute
so.
to actually
Yes.
keep,
Yes.
so that if anyone argues about
Yeah, it's 57.5.
Yes. And that relates to a point about the practicalities. So it's contended by the Secretary of State that our argument that section 56.1 should, if there's an error on the copy map, apply to the old map is overly complicated, because then who knows which map it ought to apply to. in my submission that doesn't stand, because as I've just submitted, the council keeps all of the old maps and all of the old orders, and it can check.
It was section 57.5, I think, which I had in mind when I put my two alternatives to you, which neither of which you liked very much, and said that it would be advantageous in some ways if the copy, even if erroneous, had definitive status, because that is what people will see when they go to the place in each parish, for example, to see where the rights of way are in that parish as they want to go for their Sunday afternoon walk.
Exactly so, my lord. I may not have quite grasped it at that time, but just to be completely clear on this, I accept that the copy of the map is conclusive evidence under section 56(1) until the point of review. I must accept that because that's what the authorities say. But there is no
And when you say
contradiction.
that, you mean even an erroneous copy.
Yes, even a copy containing mistakes. Because, my lord, nobody knows that there's a mistake until they go through the modification order process. And the initial presumption inter valium would normally apply if there's no error, evidence of error in the process.
Just as a slight refinement in that, when we get to the start of the review process, the erroneous copy map, as you said, is the definitive map that tracks section 56. But outside the review process, if you've got a trespass dispute, it will carry on attracting section 56, won't
Yes.
it? It's just that section 56 doesn't apply in the determination of the review.
Yes.
Okay, thank you. It's useful to keep the two things separate, isn't it?
Yes. That is exactly the appellant's point, my lord.
Thank you.
So where are we now?
I think, my lord, we've got to. I made the point that it's the definitive map and statement prepared by copy in section 57(3) that shall be regarded for the purposes of modification and conclusivity as the definitive map and statement. I made the point about shall be regarded as being distinct from the definitive map is. And my Lord Justice Holgate asked whether that's a deeming provision. And in essence, it is, but given the importance of identifying which map is definitive and should benefit from the conclusive evidence provision in section 56(1), it's important. And I was going to submit, I think as I said at the beginning, that section 57 contains supplementary provisions as to definitive maps and statements. So it would, in my submission, be a reading of the legislation which is contrary to its purpose of achieving certainty as far as possible. To construe the copying provision so that it deprives the definitive map and statement made originally under the 1949 Act of the application of section 56(1). In circumstances where the original has never been reviewed, section 53(2) has never been complied with in respect of it.
You said that again. The original has never been reviewed. You mean the original as it relates to this particular footpath, this section,
My lord, yes, I do.
Yeah.
When I say that,
as opposed to the
The whole thing.
definitive map, whatever it is. Yeah.
so this part.
In fact, you're talking about this section of footpath that we have on the map in front of us.
Exactly so, my lord.
Yeah. So this argument, if correct, would apply each and every time any particular section of any footpath comes to be reviewed. You just look at that section and ask yourself whether it has been the subject of review in terms of section 53 before,
Yes.
as opposed to
The whole map.
the whole map, whatever the whole map is.
Exactly so, and that, in my submission, makes sense and is in accordance with the statute, my lord. Because if I can put it like this: if a copying error makes it from the 1952 map onto the current map, it does so piggybacking, as it were, on the proper modifications which have been made in respect of other rights of way. So the error gets a free ride, if I might put it like that.
Substitution is where the modifications elsewhere have been made, they've been done properly.
Yes.
That then affects the way you treat a copying error on this particular section.
Exactly
So
so.
as to deprive it of the benefit of section 56.
Exactly so. And the
original map.
Yes.
I follow.
And so what I'm submitting, my lord, is that the converse should also apply. And where there is on the face of it an error, then the copying provision should not apply. An error on the part of the current copy which is being considered. If there's an error there, then section 57(3) should not be construed so as to prevent the decision maker from going to the original definitive map and statement and
Applies.
pointing to that as conclusive evidence under section 56(1). And that, my lord, is what the council did. And as I've said in my submission, they thought the way they did it is the right way. In my submission. So, my lord, unless there is anything else under the 1981 Act that the particulars of it that I can assist with, I propose to move on to the judgment.
Yeah.
The judgment itself begins on page 59 of the core bundle. We respectfully take no issue with anything that's said in the factual background or the summary of the grounds. Or indeed of the legal framework. Paragraph 16 of the judgment is on page 65 of the core bundle. the learned judge sets out Trevelyan, and then over the page at paragraph 16, he goes on to Leicestershire. And again, we take no issue with the way those judgments are summarised, but I submit that they don't directly help with the answer to this case. Particularly Leicestershire, because that judgment concerned competing alignments of a public right-of-way, that's true, but the competition was between the current map to be modified and the modification order alignment. It wasn't a judgment that can be directly applied to these facts. That's not the whole answer in my submission, which is why we're here.
It is, however, the only authority where there are competing rights of way. Mr. Justice Collins points out.
That's correct, my lord, yes. But it doesn't deal with the essential question of what is the definitive map and statement, or which rather is the definitive map and statement when there is an error on the current copy, and the learned judge identifies that as the question at paragraph 30 of his judgment at page 69 of the core bundle.
Yep.
And he says it's necessary to consider the version of the definitive map and or statement to which the presumption applies. In my submission, it's clear from that language that the learned judge was approaching the question from the premise that the presumption could only apply to one version of the definitive map. And once it had attached to that copy, it could not in any circumstances revert to the original.
Well, I'm sorry, you've lost me there. You said one version of the definitive map.
Only one.
Can you have more than one definitive map for a particular geographical area?
My lord, I'm referring to the sequence of versions. So as in this case.
I see. Sorry. Because at any one point in time, there is only one definitive map, isn't there?
Yes.
And therefore, whether it's section 56 conclusive effect, it applies to whatever is the definitive map.
Yes.
And the Trevelyan presumption, the review process, likewise, would apply to the definitive map, whatever it is.
Yes.
Thank you.
But it follows from that if there is an apparent error on the current copy of the map, then, or at least I submit that this was the premise of the judge's reasoning, that even in that situation, once the presumption has attached to the definitive map, it cannot.
Well, what you say, as I understand it, is that if you succeed in rebutting the presumption by showing that there is an error in the latest version of the definitive map, then all the factors described in Trevelyan should lead you to apply the presumption against change to the previous definitive version.
I do, my lord, but not only. I submit that there's a second stage to that. If the presumption is applied to the original definitive map in those circumstances, then I submit that it's not a question of considering Trevelyan in the usual way, So which right of way subsists on the balance of probabilities? Is it the one on the original map or is it the one on the order route? I submit that unless there is evidence of a procedural flaw, then the original map falls to be treated as conclusive. And the reason that, well, I say that for two reasons.
So I've noted that down. Unless there's evidence of a procedural flaw, the original map must be treated as conclusive.
Or to use the language accurately, my lord, I apologise, the evidence that the proper procedures were not followed.
So that goes back to the passage in
Trevelyan.
Trevelyan.
Yes, my lord. So I
I'm
say,
not sure how that's different from what I put to you. But anyway, there it is.
my apologies, my lord. So I submit that if the original map is to be treated as conclusive under section 56(1) because of the error on the copy map, and the Trevelyan presumption is engaged, as your lordship said, in respect of the original map, then the matter does not stop there. And I submit that the original map should not simply be treated in the usual Trevelyan way, i.e. which route subsists on the balance of probabilities. Is it the route on the original map, or is it the route on the modification order in front of the inspector? And I say that for two reasons. The first reason is that the original definitive map is not subject to review in this situation. So as my Lord Justice Holgate observed earlier, it's, and I hope I'm not framing this incorrectly, but it's helpful to keep that point separate. The old original map is not being reviewed. It has never been modified. And treating it as I submit in law it ought to be treated is consistent with the statutory purpose of achieving certainty as far as possible. It's consistent if one reads across to the criteria in section 32 of the Highways Act 1980 in terms of the antiquity of the original map and statement, its purpose, i.e. it was created for the express purpose of recording public rights of way, its provenance, which was the detailed process of consultation and draft provisional maps under the 1949 Act, the custody in which it's been kept, well, it's been kept in the local authority's custody, and also, my lords, which my submission is helpful, it accords with basic common sense, and that's the basic common sense that the County Council applied when the officer looked at the current copy, the 2013 copy of the map, and thought, this doesn't look right in comparison to the 1952 alignment, which had been through the full process. So, my lords, moving back to the judgment, and paragraph 31, which contains the detail of the reasoning we submit is incorrect. Dealing with that in parts. Respectfully take no issue with the first sentence, plainly that's right. The definition of definitive map and statement is subject to section 57.3. And then the judge says, section 57.3 provides that where a definitive map and statement has been modified and where the surveying authority consider it expedient to and do prepare a copy of the map and statement, the map and statement so modified shall be regarded for all purposes of part 3 as the definitive map and statement. Well, there are two difficulties with that reasoning. Firstly, the difficulty is that it does not appear to take into account the threshold requirement for copying in section 57.3, which is modification in accordance with the foregoing provisions of this part. And it doesn't mention section 57.3a at all, not that I submit it explicitly needed to, but there's no indication that the judge took into account that the threshold, or the trigger rather, for the authority's discretion to make a copy is compliance with the requirements of section 53.2, i.e. a modification order. And it's also in my respectful submission incorrect when it says the map and statement so modified shall be regarded for all purposes of part 3.
You should have said so copied.
My lord,
That's a drafting slip, isn't it? Because you accept that section 57.3 did apply to this definitive map.
in my submission, my lord, that's a point that we have to get over. But in my submission, it's more than that in this particular case. Because the effect of that piece of reasoning is that the learned judge doesn't appear to take into account what we say the essential distinction is between a map, a whole map, which has been subject to modification orders and thereby been able to be copied, and the actual copy containing this particular right-of-way with the error on it.
But there's been no previous modification.
That, my lord, is our
That's
point.
what this all rests on.
That's exactly what this all rests on, and we say this reasoning doesn't appreciate that distinction.
But although you say there is that distinction, section 57.3, if it does apply to the map as a whole. Definitive map to the definitive map, or the copied map as a whole.
Yes,
And that would include this section.
it would do, my lord. But it doesn't. It should not, in my submission, be construed, as I've said. I don't wish to repeat myself. To apply the section 56 conclusiveness presumption to the error.
So what you have is section 57.3 applying to the copied map as a whole, that section 56 on your reading of the statute applies differently if you've got a section of that copied map which hasn't previously been modified. But if you've got a section of the map which has previously been modified, then section 56 would not apply.
That's exactly right, my lord, and I needn't make any submissions on how I submit that the statute should be construed, because that, in my respectful submission, is it. I need to address the second part of paragraph 31 as well.
You dealt with the second sentence.
Yes, I've dealt with the second sentence. So I'm now taking it from in my judgment. In my judgment, if it were not already clear from section 53 itself, section 57.3 makes clear that the definitive mapping statement to which the provisions of section 56.1 applies is the definitive mapping statement as modified. And my respectful submission, that's not what it makes clear. Section 57.3 makes clear that section 56.1 is to be regarded as applying to the copy. And again, I can see that I might be accused of splitting hairs, but in my submission, my lord, it's important that the reasoning starts from the correct premise. Then the final part of that paragraph, beginning with once a definitive mapping statement is modified, it's a mapping statement as modified that is the definitive mapping statement. And for those reasons, the bench judge rejected my submissions as summarised there. I submit it's clearly an error of law to have said once a definitive mapping statement is modified, it's the definitive mapping statement as
You
modified.
should have said copied. Each time this crops up, but we can't rewrite the statute.
No. But that's not just it, my lord. It's more fundamental than that. Section 50.
What all this paragraph comes to, when you apply it to the facts of our case, is that he's saying the presumption against change applies to the 2013 version. Isn't that what this is all about?
Yes, my lord, but not only. The real problem is the disapplication. Having found that, stopping there in the reasoning.
This application of section 56 in relation to a section of the overall map which has not previously been modified.
Yes, my lord.
That's the argument.
That's the argument.
Thank you.
Okay. And I needn't say anything further on paragraph 61. Paragraph 39 is wrong for the same reason, so I don't think I need add anything to that.
Well, that just repeats what you said before, and refers back to what you said before.
And there is more of a fundamental misconception here, in my respectful submission, because it's not modifications that make the map definitive. It's the other way round. The definitive map, as defined in section 53.1, subject to 57.3, in normal circumstances, is the map to which modifications are made. So the basic point is that the presumption, or rather section 56(1) was not prevented from applying to the original definitive map and statement. And there is nothing on the face of the statute or in any of the authorities to suggest that that's how it ought to be construed. My lord, if there's nothing else on the judgment, I'll move on briefly to...
Are you going to say anything about paragraph 33, which seems to be quite an important paragraph, where even though the judge is applying a presumption adverse to you by reference to the 2013 version, he says in the end, well, never mind presumptions, there is a finding on the balance of probability as to what the correct route is. So any presumption has been rebutted.
That goes back to my point, my lord, about the second stage, if the modified Trevelyan approach is followed. So it's not just... If there is no evidence that the proper procedures were not followed, then...
This is your section 56 point.
Exactly. Exactly, my
So
lord.
your answer to my lord's question is, like, you accept what he says, subject only to your section 56 point.
That's right, my lord, I'm grateful.
But the effect of the section 56 point, if it's correct, is to treat what was on the 1952 definitive map in relation to this section of the footpath as conclusive. As I understand it, it shows the footpath running through Yew Tree Cottage.
Well, my lord, that was an not quite. The inspector doesn't
Wasn't
make that.
showing it going through the other property.
Well, no, my lord, but there never has been any indication of a line going diagonally through the courtyard of Yew Tree House either. So those matters were for the inspector to decide. We say treating it as conclusive. So that is the starting point. She drops anchor in my submission on the original definitive map, treats that as conclusive absent procedural issues, and figures out, which is well within the expertise of any rights of way inspector, where the legal alignment, i.e. that the alignment shown on the 1952 map, is on the ground now. Because if she doesn't do that, then she can't reach a rational decision on whether what is shown on the 2013 copy is right or not.
Well, she clearly accepts, doesn't she, the council's version of what the 1952 map shows, which is that it runs through Yew Tree Cottage. She says that in paragraph 10, where she summarises what they say, and we've seen that their case was that it ran through Yew Tree Cottage, and she talks about the eastward drift, so that it now runs through Victoria. And she also has regard to evidence that there used to be, until this dispute, a sign showing the route running through Yew Tree Cottage premises. So the fundamental assumption of your case has to be that the 1952 version shows the path going through Victoria Bungalow, but that's simply not the inspector's finding, is it?
Well, no, it's not, my lord, and that we submit is not the conclusion she would necessarily have reached had she treated the 1952
No,
map as conclusive.
this is simply a finding about what the 1952 version shows. So you've got to decide that before you apply any presumption about whether it's right or not. And her finding is that 1952 goes through Yew Tree Cottage.
Well, my lord, in my respectful submission, that wasn't her finding. So if I could
Okay.
ask you to turn, please, to paragraph 33 of the order decision.
Yeah.
There are a number of evidential points that the inspector left hanging. And she finds there that on both maps, i.e. the provisional and final definitive map from 1952, the line of ZR281 again shifts slightly further to the east, so as to run through the buildings 4, 5 and 6 of Yew Tree Cottages before reaching the street. Now, that is a finding that the 1952 definitive line was drawn as running through land which is on the current geographical configuration, not in the Yew Tree Cottages map.
Well, that's a matter of fact, a matter for the inspector, not a matter of law, not subject to this appeal. You've got 10 minutes.
Yes, my lord. What I'm setting out, if I may, is the difference it would have made had the inspector treated the 1952 map as conclusive. So she would have had to clarify her finding that the definitive map runs on a north-south alignment over land which is not now included in the defendant's property. She says that, but she doesn't, in my respectful submission, draw any conclusions on that point. Thirdly, secondly, and this is the most important point, the inspector does not deal with the fact that none of the maps show part of the path running diagonally through the appellant's courtyard. It's clear at paragraph 46 of the inspector's decision, the order decision, that she does not include, as a matter of fact, any of the definitive maps in her assessment of the positive evidence to support the line of this footpath. And when she says, I conclude that the most likely explanation was that the public used the route ABX and then continued via XC, I respectfully pose the question, explanation of what? It's not a comparison between any definitive line and the route on the modification order before her. So had she treated the 1952 definitive map in the way that we submit she should have done, it would have been positive evidence to support the legal line of the footpath as a matter of law. Which she would then have had to consider together with the Ordnance Survey records and the initial parish survey of rights of way. In reaching her conclusion. The only positive evidence the inspector identifies to support the line of the footpath, which must be the legal line, is the Ordnance Survey records in the initial parish survey of rights of way. And that conclusion is reached without assessment of as conclusive evidence the original map and statement that we submit she ought to have treated as conclusive as a matter of law in the circumstances of an apparent error on the copy map before her. So it cannot be said that she would necessarily have reached the same conclusion. And for those reasons, unless I can assist the court any further, we submit learned Judge erred in law by construing section 57.3 so as to deprive section 56.1 of its proper legal effect. The inspector's decision may have been different. Had she not erred in law. And so our application is that the court, if minded to find that the judge below erred in law, to quash the order in accordance with its power to do so under paragraph 12 sub 12 of schedule 15 of the 1981 Act, which is at page 57 of the authorities bundle.
In your when you set out the structure and you had your various headings, your fourth heading was, I noted down the heading as correct construction. Could you very helpfully just in a sentence or short paragraph just summarise what you say the correct construction of the section is?
Yes, my lord, I can. So if, I'm sorry, my lord, if, just bear with me one moment. In the case of an error on the face of a copied map under section 57.3, section 5, that section, together with 3A, should be construed so that any definitive map and statement in subsection 3A includes any right of way on any definitive map and statement.
That section, together with 57.3a, should be construed so that any definitive map or statement includes any definitive right of way on any definitive map or statement.
Leaving out the first definitive, my lord, any right of way on any definitive map and statement.
Right. Thank you very much.
Can I just ask one question about the map we were helpfully given? We've had the, in response to my lord's question, we've had the alignments blown up so we can read them a bit more carefully. And you referred several times to the part of the footpath which diagonally crosses your client's courtyard. If I try and identify what that is, do you see on the plan the base yew tree cottage, the words?
Yes.
And you can see the capital T for tree. Does the diagonal bit start at the top of the T and run? I can't say northwestwards. Do you know what I mean? That's the
I do, my
diagonal
lord.
bit,
That's the
right
bit.
at the top. Of
Right
the,
at the top, yes.
Yeah. And you say that particular part which is blown up there, we can't see on what we've got on, for example, at page 102 of the core bundle.
That's my submission, yes.
I just note on page 102 of the core bundle that when you reproduced in your submissions the definitive map from 1952, the scale is different.
Yes, my lord.
Because you can tell that, because on the diagrams to the left, we can see PO, presumably post office. Would that be right?
Yes, my lord, that's
Yeah.
my understanding.
And you can see the rectangle for the post office
Yes.
to a larger scale on the definitive map you've reproduced there. So we haven't in fact got the northern extent of the definitive map in that reproduction. See the position of footpath, FP as well, it's halfway up the diagram instead of being below the halfway mark. The scales aren't the same. Okay, thank you.
Thank you very much. 2 o'clock.
Court rise if able.